Hello friends, in the series on the income tax cases, today we will discuss a very important case which is based on search provisions. In the present case, a very pertinent issue was before the Honorable Delhi ITAT that if any search is made in the premises of any assessee, but when the search warrant is issued and when the panchnama is drawn, both are not in name of the assessee but in the name of someone else. So only because the search has been made in the premises of some assessee gives a right to the revenue to make the assessment as per the search provisions under section 153A. This issue has been decided by Delhi ITAT in the case of Assistant Commissioner of Income Tax versus Arora. This case is reported in 127 ITR Tribunal at page number 14 and the date of the judgment is 11th June 2025. The present case relates to the assessment year 11-12 to 15-16. When the search was made on the assessee on 6th February 2019, then the assessing officer issued notice to the assessee under section 153A and accordingly the assessee filed the return and subsequently the notice under section 143 subsection 2 and questionnaires under section 142 subsection 1 were issued to the assessee and the assessee made due compliances of all the notices. During the assessment proceedings on the basis of dumb documents, loose sheets, uncorroborated WhatsApp chat, the learned assessing officer made additions of crores of rupees without giving any opportunity of cross-examination. The assessee pleaded before the assessing officer also that the search on the assessee was on a mistaken identity and even the name of the assessee is not there on the search warrant. But the AO was not convinced, so he made the addition of crores of rupees in a high-pitched manner. When the matter was before the CIT appeal, the assessee pleaded that and produced the copy of search warrant, the copy of panchnama. On the perusal of the search warrant and the panchnama, it was very evident that there is no name in the title in which there is evidence from that the search has been made on the assessee. In the name section, there was no name of the assessee, but the search was made at the premises of the assessee. Only the address of the assessee was there, but his name was not there. The CIT appeal on this plea of the assessee quashed the assessment proceedings and also gave relief to the assessee on merits. The assessee also produced before the CIT appeal the order of the tribunal in the similar facts in the case of Sanjay Jain versus Principal CIT, in which the tribunal has quashed the whole assessment proceedings on the basis that the search warrant and the copy of the panchnama was not in the name of the assessee, and very interestingly, both the search warrant sequence number or the serial number were in consecutive number, meaning thereby that the same mistake has happened by the department in the case of the assessee and in the case of Sanjay Jain also. When the matter came before the tribunal, because the revenue carried the matter to the tribunal, even though in all the 5 appeals the tax effect was 60 lakh, but the department was contesting. So when this matter was taken up to the tribunal quashed the assessment proceedings both on the basis of monetary limits and on the basis that in the present case from the facts it is very clear that there is no search conducted on the assessee. The search warrant and the panchnama do not contain the name of the assessee. Only because the search has been made on the premises of the assessee, it does not give a right to the revenue to make the assessment as per the search provisions. The tribunal also said that in the present case, since the appeal effect is less than 60 lakh, so there is no case of the revenue in pursuing these appeals. Friends, this case is very important because it has been seen that when the searches are made on some group, then on the basis of those searches, subsequent searches are also made on the various persons by not even mentioning the name of the assessee on the search warrant and the panchnama, and those searches are made in a very loose manner. So this case can be very helpful for all those assessees. At the end of this video, once again I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus Arora and this case is reported in 127 ITR Tribunal at page number 14, and the date of the judgment is 11th June 2025. Thank you, friends.